Hello, friends. Welcome once again to the Weekly High with LHD show. This week, along with my co-host L. Subramaniam Subu, as usual, we have with us N.S. Nappinai. She's a Supreme Court lawyer and founder of Cyber Saathi, among many other things. She focuses on litigation and policy work, apart from social responsibility engagements for training judges, police, armed forces, students, and industry people. She appears as counsel in cases pertaining to constitutional, criminal, IPR, and cyber laws. She's also an advisor to Maharashtra Cyber Police, a senior panel advocate to the Central and Western Railways, a prolific writer, speaker, and author of the book Technology Laws Decoded. Must read, honestly. And she's also an advisor to the Tamil Nadu eGovernance agency. Welcome, Nappinai, on this board. And among other things, we will be discussing the Facebook saga with Australia and the ramifications of media news outlets versus social media outlets. We'll talk a little about smart cities. We'll talk a little about how or rather a lot about the proposed intermediary guidelines by METI, which Napanai can throw a lot of light on it. The governments and the companies and governments preparedness on cybersecurity, cyber crimes in the light of cutting edge tools like the whole AI suite of tools. Then of course, we have the social media versus government pact, which is an ongoing issue. And I think when you have a person like Napanai on the show, one cannot but not talk about data privacy versus national security debate. So, Napanai, let's first have your thoughts on Facebook, sort of unfriending Australia, then sort of tentatively friending Australia and getting it back on a negotiating table to discuss things, as Scott Morrison, the Australian Prime Minister, put it. Incidentally, he's already spoken to, not very surprisingly, spoken to Prime Minister Narendra Modi about it. I think he's also had, we have learned that he's also had chats with Canada's PM, Justin Trudeau. Yeah. So now the interesting part, I think, because we are on the social media side of it, so I mean the news media side of it. So we know, like, okay, fine, it takes a lot of effort. Subbu will tell you more about how much money goes into creating a whole news organization platform. So it hurts when somebody takes your lunch off the table and offers it for free without you getting anything in return.
Leslie, it's always a pleasure to be on the same podium as you. And I'm looking forward to what I know is surely going to be a roller coaster ride. So thank you for having me here. And I can see that without much ado, you have jumped right into the deep end of things. So, everybody assumes that the narrative, whenever it comes to social media and government, social media and now news, media or legacy media, everyone assumes that it's a black and white narrative. So on one hand, you will have people speaking about how the entire Australian law is predicated on a big industry mogul lobbying for something, right? On the other hand, you will have the naysayers on the other side who would tell you that the social media giants are the big bad wolves and therefore we need to protect ourselves from them. But narratives are never so clear, right? So black and white as they seem. So when we talk about this fracas, it's actually quite simple. One, when you narrow it down to the perspective, which is what you just mentioned about what is it, and as all of us know, so I don't even have to go into basics, but just to clarify there, news per se does not carry any ownership right. It's the presentation of that news that carries a copyright. So where there is a copyright violation, then you already have your remedies in law, right? Where, however, the situation then blurs, and that's the situation we are in now in terms of whether sharing of certain kinds of content on social media amounts to that copyright violation or not. And therefore, consequently, should there be a gain to the news media channel, consequent to the social media platform benefiting from this sharing? That really becomes the crux of it. It does not matter whether a big conglomerate or a small startup question the right of social media to do this. It also does not matter if social media believes whether a law is valid or not. But the one thing which they really have to get in mind, and in fact, interestingly, I wrote about these syndromes in 2019 and it was published in 2020, early 2020, in Nani Palkiwala's Festschrift, where I titled my piece on rethinking social media through prisms of democracy, liberty, and victim rights. But the first construct, and I split the article into two. The first construct I discussed was social media as a sovereign. And now you know where I'm going with this
Of course.
piece of information.
Sue loves that word.
Yeah.
It is the old government of Google. We are back.
Yes. It's not just about Google, Facebook, WhatsApp, etc.
Yeah.
Everybody, where there are certain delusions in terms of what are their rights or entitlements. So the first part, therefore, I dissected whether they could amount to a sovereign. And the long story short, for the long story, you have to read the article. But the long story short, I pointed out how ultimately you may claim citizenry, you may claim a lot of things, including your own currency also, which is what they're trying to do with the cryptocurrency regime. But everything still boils down to you and I, who are the users and who are anchored to some land. We are not floating in ether. We are still anchored somewhere. And we are therefore amenable to the jurisdiction of the laws of the land, not just as users, but as the conglomerates who are offering their services in various jurisdictions. So you offered your services in multiple jurisdictions. You can't now cry foul. You have to comply with the laws of every land. If you have a problem with it, follow due process, take it up before the courts of law to decide whether it's valid or not. But to arm twist, to do these kind of, muzzle power, etc., is not appropriate.
Nappinai, I have a question here. The question is, earlier you mentioned that the news organizations had allowed Facebook to carry content from their, portals, right? They had not objected to it when Facebook was doing it.
Right? No,
Right?
I did not say it at all. If anything I said gave that impression, I would want to then clarify it. Okay. What I said was that users have been posting. Users, not news media. So I was saying that there are two kinds of things you could do. One is where your own copyright content is reproduced. You have a right to contest it. Two is where links to your copyright protected content are reproduced. You need a law which will clarify whether that also amounts to a violation or not. That's it. It is not about permitting something to happen over a period of time and then pulling back, etc. It's about, and I had just started off with and stopped with this limited aspect, which is that there is a statutory right that vests in certain kinds of content. And you have a right to protect it as news media. The government has a right to pass laws as per due process if it believes it is relevant for the nation or a public good. If there is a disproportionality in that, any person affected because of the disproportionality or the citizenry of the nation are entitled to contest that law.
So here is
not use muzzle power. So this is the summing up of what I wanted to say.
So here is the question. As a user of Facebook, I have posted an article which appeared in any publication. some publication. I've just posted it on my page, right? My friends see it, it gets viral, and so on and so forth. Now the question is, the cause of action is between the publication and me, right? How does the platform get involved in that? Because I'm only using the platform.
Excellent question, Subbu. And in fact, this is one of the reasons why the delusions also happen in terms of the sovereign rights, etc. Because ultimately, and this is something which we are all discussing in multiple contexts now, the intermediary safe harbors. Because
Yes.
as you rightly pointed out, the issue here is a user is uploading something. So the platform cannot be held liable for what a user does.
Correct.
The issue here, therefore, is not about prosecuting the platform because the platform has a safe harbor protection. Or simply put, whenever something is shared by a third party on a social media platform, the social media platform cannot be held liable for violation of other person's rights, right? Unless they consciously promote something. Right?
Right.
They have to have affirmative action for them to be held liable. So therefore, the issue now was not a copyright issue from the Australian law perspective, but of an economic value.
Yes.
Exactly. So that is exactly where I was coming to. Now, let's assume that millions of people are taking articles from millions of publications and posting it. Amongst their friends, it's viraling, right? And a brand comes and gives money to Facebook to appear on the top where my friends are reading that article, right? Now, obviously, Facebook is making money on it, no question about it, right? Now, in this case, Facebook as a platform is making money because people like me are going and consuming that content and are staying on that page. Correct? Why should, from a purely legal perspective, I can understand the economics of it, I can understand the politics of it, all right? But from a purely legal perspective, why is it that Facebook should be made liable to share that money with the creators of the content when all that Facebook is doing is allowing me and millions of users to put that content and consume that content?
Precisely why I mentioned earlier itself the public good concept. Because if you look at a few provisions, even under the Copyright Act, it is not just about making copyright content available to public. So that is the bottom line in terms of copyright laws. That no work should be withheld. It should not be monopolized. There should be a platform which will ensure that there is dissemination. But that dissemination comes at a price. So effectively what you're asking for is also the same thing. So though you are addressing it from an economic value or a political or otherwise, it still boils down therefore to the same law. And I'll give two examples on this. The first is compulsory licensing. Again, where people are holding on to something and not releasing it for public dissemination. So the more information, works, it could be anything, movies, music, news, whatever it is, the more it is disseminated, the better for public is the construct, right? So when you do it this way, ultimately some benefit has to flow to the creator. So law tries to balance these two things to say, one, where somebody is withholding something, we will allow you to take the rights and the creator will be paid. And the next level of it, a much tighter regime, which is the statutory licensing regime. And the statutory licensing regime is what I had drawn on to make this point with respect to Facebook versus Australia in a recent interview, where I clarified that what is the intent or purpose behind a statutory licensing regime? It is beyond even compulsory licensing. Because where a government may feel, and if you look at even 31D for India, at that point of time, India felt that it needed to buttress the radio and television channels. At that point of time, it was dealing with predominantly local channels, government enabled channels, etc., etc., right? So when you have a plethora of channels which are just startups and you want to give it support, and you bring in a law which allows for a level playing platform. And therefore, the law was brought in to say that you have to provide all your content and there will be a statutory fee that would be fixed by the board, right? So this is how the concept of copyright and public good from two angles. One is for their access to this kind of content and also for payment to the creator came in. So in a similar fashion, today, if a government feels that news media requires this kind of support, and they feel that this is actually beneficial for public good because a social media platform allows for a wider range of dissemination, but we still have to protect the economic value and the creator rights of the person who has put in their work, in this, because it's not just sweat of brow theory now. It is also the creativity angle on it.
I see there are a lot of important points are made out here. The reason I'm interjecting is because I know this will get into a very, very detailed kind of explanation. And I know Subbu is going to ask all about, I think he'll clarify everything about his law practice and
I was also beginning to feel like a lecturer right now in law.
My fun, I'm playing a little devil's advocate and a bit of a contrarian here. My view is not my view, but one of the views that I do have is that if I'm a private company, I have a platform, millions of users are coming and putting stuff, right? And I'm making money purveying that my inventory. Okay, I'm only giving my inventory, right? Now somebody comes in, and this has been going on for many years. Suddenly the news guys believe that, oh, okay, this guy, I'm making a lot of money and they're not losing money, but I'm making a lot of money. Okay. Then they petition the government and they say, no, we should also get that money. I should, as a private individual, private entity, have the right to say, great, I don't want to share the money with you, but you know what I'm going to do? I'm going to not carry anything from you. Right? I will not allow you inside. I will not make that money, no problem. But I'll be damned if I'm going to give my money to you, or simply because some user somewhere or millions of users somewhere have decided to post that content. Why should I be blamed? Why should my monies go away just because my users are using your content? So I'm not twisting.
Just to simplify your point, you're just asking what was wrong with Facebook blocking the news.
Correct.
Exactly.
Absolutely. They were well within their right to do that too. So, in fact, if you look at how things have changed in just a few days, on one hand, there was a little bit of a global furor that a social media platform is flexing his muscles and trying to do one-upmanship against a government. So all governments, and not just the government which is threatened, but all governments started feeling threatened. But then within just a few days, already you're seeing a pullback, not because there has been a change of mind, but because the narrative changed to show that people may no longer want Facebook as the platform for sharing of news.
Exactly.
So if you look at yesterday's news, it says, oh, Facebook now wants to offer it again. Will we then say, thank you, but no thank you?
Exactly.
Yeah, I don't think that's going to happen in any hurry. But as of now, let's restrict, because I think even in India, we had a daily hunt, we had in shorts. I think they should charge, they should pay the news media, the content creators, basically. I think something anywhere between 5 or 7 lakhs or something, and then they reduced the amount. Then people moved off the platform. So I think economics is going to take precedence at some point.
I just want to clarify this one thing, Leslie, that we cannot also take away this kind of autonomy, a corporate autonomy, save and except by a law which can be constitutionally sustained. So
And
we have to
constitution
be sure
and
of
constitutionally
that,
challenged.
because otherwise we are kind of, it's a slippery slope, right? We'll
Exactly.
otherwise move back to a license Raj, and I don't think any of us want that
Yeah,
happening.
and also, from a content creation point of view, you would want to be discovered on the internet, else you'll just not be discovered. So the point is, if the algorithms don't work, I mean, in all fairness, these guys have invested a lot in the algorithms. So I think that Via Media is sitting across the table, and I think Facebook and Google will have to.
It's an eyeball to eyeball. It's a question of who blinks first.
Correct.
You know?
And according to a 2020 FICCI EY report, this is just for our viewers, that there were 300 million users of online news sites, portal, and aggregators in India, making up approximately 46% of internet users and 77% of smartphone users in India at the end of 2019. This is that FICCI EY report. 282 million unique visitors. So India becomes the second largest online news consuming nation after China. And this is the reason why this issue is so important. And if you look at the digital advertising spends in India in 2019, they grew 24% YOY, touching 27,900 crore. And this is expected to grow to 51,340 crore by 2022. So this is the reason why why we are discussing this topic. Uh, I'd like to segue into another topic, which again involves a little of it's a news-based thing that we always discuss. But yes, there are different angles that we could explore since Nappinai is there with us. That is about Saudi Arabia building a smart city in the desert that will know its residents better than they know themselves. Of course, now that clearly brings up a very different kind of issue out here. Uh, I know.
All that it means is that Saudi Arabia is now actually going to do a joint venture with Google, and because Google anyway knows more about us than we do, right? So all that they're going to do is just borrow the algorithms and pay Google a whole lot of money and say this is the way we're going to go forward.
No, but there are two interesting aspects out here. One is, of course, India spoke about those 100 smart cities to begin with. We spoke about a 2 lakh crore budget, if I'm not mistaken. Uh, Nothing really much has happened. I mean, in bits and pieces, yes, truly it has happened. But look at the budget allocations. As of now, uh, we really don't have much of a smart city to talk. In the other way, I just the other day I was passing through Alsur Lake, and I saw that huge board of smart city Bengaluru. I saw the potholes below. I saw the traffic below. Things have improved clearly in bits and pieces. Today we have the fast tag, we have UPI, we have a lot of e-governance moves. So I think let's give the devil its due clearly as far as the work is concerned. But at the same time, a lot needs to be done. But since we already have Nappinai and we have been speaking about these things, I'd like to, relate this to the face recognition stuff that Nappinai has been talking a lot about, especially in UP, for instance, to protect women. So here you have a smart city that will ostensibly protect women, protects its citizens, give you more services. You have face recognition software, which also at first blush and really at face value, yes, it is all here to protect the citizen and give you better services. Napanai, your thoughts, I believe.
I am deeply concerned. I can tell you this much because
Absolutely. I mean, this is just George Orwell all over again.
so
No, but
you're talking about a kind of panopticon of a state itself, right?
Exactly.
And when you ask about this whole women aspect, nowadays, if you look at all the things that are being done, a couple of years back, when this whole facial recognition technology assimilation into governance took place, if you go back to see where the funding came from, substantially it came from what is called as the Nirbhaya Fund, which is meant to be utilized for protecting women and children. So it's no surprise that a lot of intrusive technologies and their usage and governance is being justified on the angle of protecting women and children, right? So is it really doing it? Or is it actually going to take away their rights? There are so many studies today which show whether you're talking about it as watching pornography and therefore somebody is supposed to be monitored and therefore you're supposed to be named and shamed or something like that, or whether it's, a physical movement, CCTV cameras everywhere, which is going to supposedly protect women, or facial recognition technology, or getting every citizen's data point, every single point on board, so that, wherever you're seen, whatever you're doing, we can get you in 1 minute. The whole problem with this concept is, on one hand, with India being so populated, and today in today's data-driven world, therefore we have again become one of the richest nations, right?
Absolutely.
On two
Absolutely.
counts. One, because of our population, and two, because ours is still an open, liberated economy where people can come and utilize this resource yet again, right? So therefore, on one hand, it's overpopulated, and when there is a crime, there are genuine concerns and problems that the law enforcement is facing in terms of investigation and apprehending the victim. Apprehending the criminal. But on the other hand, you have something like this, which is about a preemptive measure to say that, in India, watching pornography is not an offense. Uploading, disseminating, or selling, sharing, etc. is an offense. So if you're just watching pornography, why should that be assumed to be protecting women? Then you're again applying the same yardstick, the patronizing yardstick, that women don't watch porn, right?
Yeah,
and there are studies which show that women substantially do. So what exactly is the purpose behind this attempt? And if you look at the Puttaswamy judgment and the 3 grounds they laid down of a law to exist, and the law being for a legitimate state aim, and that it should be proportionate, all 3 are not met here if you talk about the UP situation.
Yeah, and by that logic, I think we'll have to stop. We'll have to close down the Ajanta and Ellora and everything. I mean, because that is also. I mean, what do you do?
No. So
All
here
our
is a
Kama
question
Sutra
for you.
books and all that.
Yeah, here's a question for you, Nappinai. The question is that, see, on one hand, state governments and central governments wax, eloquent about doing, protecting the rights of the women and children, right? And then they go to, say that we're going to use technology to make sure that there is constant surveillance and data is available. We'll catch them wherever, they go, etc., etc. Question is, why the fundamental premise of any of this is that if there is a crime, if there is an offense, the offender must be caught, punished, and exemplary punishment should be meted out, so that there is a use case to suggest that if you do this, this is going to happen. My question is, when we are spending so much of money on these, right, which could be suspected, as you said, and I completely agree with you, why can't we spend a fraction of that amount in speeding up the law enforcement, speeding up the punishment mechanism, speeding up the process, and speeding up this exemplary punishment? Why don't we do that?
You can't treat it as either or here. No? It'll have to be, you have to try multiple options here. Right. So to that extent, I would not totally be with you to say, oh, yeah, it is better for you to put it here rather than there, because why not try everything? My concern is actually a lot more deep-rooted. You're collecting data. You're collecting a lot of data about citizens. There is no personal data protection law still in India, which tells us what a government can do with our data. Right. And there is no certainty. Therefore, you're going around setting up CCTV cameras, you're going around collecting a lot of data, and rampant collection of facial recognition technology information, right? From schools to public roads to everywhere. What is it that is regulating this usage? Or more importantly, what is the law or regulation that sets out the purpose limitation? How are you going to block a law enforcement agency from not abusing the data that it is collecting in general, and only addressing or viewing data that is pertinent to women protection? And even when it comes to women's protection, the reason I'm skeptical about the efficacy of it is, let's take that instance of the New Year sexual assault case in
Bangalore,
where the culprits were caught on CCTV camera. And I was shocked to hear the top police cop of Karnataka coming on a news channel and saying, ask the victim to come and file a complaint, we will take it up. The law does not require a victim to come and give a complaint. The law only requires an information to be given in writing. So anyone can start the process of law, and nothing stopped you from apprehending the culprits. We have had a horrific crime in Mumbai of this girl, you know, the techie girl who landed in the train station, and nobody could trace what happened to her. And then there was a CCTV camera grab of the person who escorted her outside.
Exactly.
But there was still so much confusion because the camera grab was so bad that they could not really compare it sufficiently for effective usage. They still had to rely on standard investigation processes to sustain that case. So when we are seeing the inefficacy of CCTV, we are seeing that there are no standards laid down, technical standards for what is a good methodology to ensure protection, and most importantly, a law that limits usage of this kind of data. It actually brings us to a higher order of Aadhaar, and where in the Aadhaar judgment of Puttaswamy, the court already struck down anything that was excessive, where it jeopardizes the liberties of individuals because of these interlinking of multiple data sets. And here is a situation where you're capturing literally everything. Every time we talk about facial recognition technology and its abuse and all that, the first image that comes to my mind is of Tom Cruise entering this Gap store in Minority Report.
Yes.
And then, you know, the message boards, because he's trying to hide himself. And here is a thing which tells him what he likes to shop there and what he should shop there. Correct. So that's the situation we are pushing ourselves into.
See, the other problem, Nappinai, is that, you know, although the Supreme Court said in the judgment that Aadhaar is not to be made compulsory unless and until there is a requirement stated for that. Consequently, the banks, you know, it was very clearly that RBI issued a circular saying that you cannot demand Aadhaar for opening of a bank account. Today, in Bangalore, when you go to open a bank account, the branch manager tells you, give me Aadhaar card. Yes. When I fought with him, he said, sir, I have not seen the circular. If you want to open an account, I need Aadhaar card. Otherwise, I cannot open an account.
So for
imagine a daily level
out there, I'll give a very simple solution for not just this situation, but any situation you'll face in the future with any kind of authority figure. You know, even when you go to a restaurant, they ask you for your mobile number. You know, I refused to shop at one particular place because they insisted that unless you give your mobile number, we will not allow for a billing to be done. Yeah. And then that same shop then faced litigation for the same issue thereafter. So here is a simple solution for you. You don't have to fight with anybody. All you have to do is tell them, please put it in writing and say, this is the only document I have to give. Then I will give it to you.
They don't do that.
They don't do that. I asked them that. I asked them. And they said, we can't give anything in writing. You want to open an account, you have to give the Aadhaar card. No, my problem was not that.
Absolutely. Then all you have to do next is you put it in writing. Nobody stopped you from doing it. Then they will deny it. But when they deny it, they also have to open your bank account without the Aadhaar then. Simple.
But then,
viewers,
but let me tell you what actually happened.
This is very important for you viewers. Please pay attention.
Yeah, it's actually very simple. When you say it with conviction, when you say it simply to say that this is what the Supreme Court has decided, and if you do this, one, it violates the Supreme Court's order. Two, it could amount to contempt of court.
Contempt of court, correct.
And three, more importantly, now this is no longer the law of the land, and therefore you are committing what is the data protection you're giving me? Because there is a misapprehension that until and unless the Personal Data Protection Bill becomes law, India does not have a personal data protection regime. We do have under 43A of the IT Act, there is also a criminal provision under 72A, which makes body corporates liable. A bank or a restaurant is very much liable still. The problem is only with respect to government, which is what we were speaking about earlier. So today when you tell them, show me what are your data protection provisions to say that you will not abuse this data, I'm telling you politely 2-3 lines explaining things. No problem, madam. You please go and sit. We don't want your mobile number. No problem, madam. You give whatever document you have. We will, and the next step you have to ask is, please show us what is the provision or what is the process. Every bank, everything needs to have a policy document, right? Which is the process they'll follow. Please show your process document which says only Aadhaar is acceptable. No problem, I'll give it to you, right? And then they will have to necessarily show the process document which will list multiple documents, because they cannot, under the RBI provision, have only one document. And I'm just using
and even the website shows multiple documents if you
exactly. So you have, we were talking about social media earlier. The good thing about social media, that is why I keep saying we should not throw the baby out with the bathwater.
Yes.
We have to be careful what we wish for, because we may actually get it.
Get it.
So let's be careful in terms of even social media or our social media bashing. In fact, even when this whole Facebook Australia thing happened, that's what I said. There seems to be these wrong assumptions that governments don't want social media. That is incorrect. Governments love social media because that also gives an opportunity to voice their opinion without legacy media playing God, right? And secondly, we as users need it most. That is the platform which gave us this amazing opportunity to voice our opinions freely, right? So look at the kind of power you have in your hand. When you say, no problem, we will then also put it out to you don't even have to run all the way to RBI. You can tag RBI on your Twitter and put it there saying RBI so-and-so bank is insisting, please confirm.
Correct.
And then they will become answerable to RBI. So the law can be used very simply, but remember, don't use it with anger. Don't be rude to any authority. Remember, they're also just doing their job. I'm saying it predominantly because of police and other authorities also. See, I work with police. I've been a defense lawyer all my life, in terms of criminal law. But I have been working with police over the last 20 years in terms of training them and advising them, etc. Right? And then suddenly you see the flip side of it. And you realize there has to be a balance. When they are doing wrong, point it out to them. Be firm, but don't be rude. Be assertive, don't be angry. Because in the anger, in that noise, things get lost.
Absolutely. It's a very common sense approach, basically.
This was a common sense approach, because ultimately, instead of the 5 steps I told you, you still have an opportunity for, you can actually finish your work in just 1 or 2 steps.
So, it's about getting your work done. Yeah, and you made a very important statement out here that don't throw the baby with the bathwater, because this is also what I've been insisting over a period of time. You may actually get what you wish for, and which we all subscribe to, which means I'd like to segue into the third topic that we planned this year, this week. So we spoke about the intermediary, proposed intermediary guidelines, or whatever the changes are. So you have written a piece and you have been interviewed on that also. So please tell our viewers actually what are these changes that we can, and what exactly is happening in that.
So a lot has been happening, and for more than 2 years now. And I truly hope that this is now going to see the light at the end of the tunnel now, because we really need these changes, good, bad, or ugly. We can always keep debating till the cows come home, right?
Yeah.
So here is what my wish list is. 1, that there has been a lot of confusion. See, we've been talking about various aspects in terms of intermediary liability. I'm also amicus curiae before the Supreme Court in a matter where we are actually dealing with 2 of the most horrific crimes against women and children. Dissemination of child sexual abuse material online, or CSAM, and uploading of rape and gang rape, actual rape and gang rape videos online. In this case of Prajwala, which for the sake of shorter thing, I'll call it Prajwala versus Union of India. So when we are talking about and in that case, we are evaluating the use of artificial intelligence to preemptively not block, but quarantine content until human intervention checks that it is innocuous. It could be a news item, it could just be a movie having a rape scene or something like that. But unless and until it is verified and then uploaded, do not allow it, is the argument that is still going on. It may or may not happen. The reason I'm pointing that out is when we are talking about all this, a lot of issues in terms of intermediary responsibility as well as liability came up. Are they supposed to act as gatekeepers? Aren't they jeopardizing their own safe harbor? Because, under Indian law, you have it under 79 IT Act, and the origin of it came from the US Communications Decency Act 230 section, right? Now, 230 gave this lovely umbrella protection to them, and that article is likely to come out. It's called the 24-word sweetheart deal. So the sweetheart deal is we protect you against anything and everything, because free speech is what ultimately everything is about.
Which is what Trump threatened, right?
Huh?
Which is what Trump threatened to invoke, to revoke.
I'm not even going to go there, because then we'll get into a different conversation there. But long story short, safe harbor is just a protection to an intermediary as long as they don't have control over the content on their platform. So the new proposed guidelines are trying to create this delineation with respect to what is content that is third-party content and what is content which the platform actually does have control over. And this is where it is a very interesting connect to the very first topic we spoke about in terms of the news media, as well as what the platform's algorithms may be enabling.
And they're also generating content. Yeah. Even social media platforms actually, they have newsrooms. They do.
Absolutely. Many social, particularly content generation platforms, right?
They have news editors. They are moderating the content. They're doing everything.
They're doing everything. But then these are all the gray areas where law is still evolving. So clarity in terms of what amounts to third-party content and what amounts to content which is being moderated by a platform, and therefore they have to be held liable, is a very important aspect which we could expect in the new intermediary guidelines. And I'm hoping that if it is coming in, it would come in a manner where it is precise and clear and not ambiguous again, right? That is one aspect. The second aspect, which Meiti has also given a soundbite on, is with respect to, which is what I have also talked about, the takedown aspect. So if you look at 79 itself, there is already a provision under 79 for takedown under the intermediary rules, which mandates that takedowns have to happen within 36 hours. The only thing that the Supreme Court did in Shreya Singhal versus Union of India was, it struck down, there were three ways you could do a takedown. It struck down one aspect of it. So if a user writes to a platform, there is no, if the platform refuses, even then the platform will retain its intermediary protection, safe harbor, right? However, if the notice goes from a government authority or a court, then it mandatorily has to comply with it within 36 hours. The only protection that is available to the platform is that the order should still comply with Article 19(2), because India's right of freedom of speech is not an unfettered right. It comes with some restrictions or limitations which are captured in Article 19(2). So as long as it falls within that, then the order is sustainable. The issue here is, and I'll bring in this whole thing, the Twitter issue that has been rounds, is who decides whether the order is within Article 19(2) or not. So my opinion is that a corporation cannot decide that, because then that becomes absolute anarchy, because it's not just about a corporation, right? You and I can also start deciding that. We can then start saying, no, but this law is a very bad law. I have my opinion on many laws which are very bad laws. But can I stop complying with the law because I think it's bad, right? If I do that, I can, of course, do that.
Yeah,
but I will then be liable for it,
yeah.
for a violation, right? So here, the only alternative for anybody who is contesting the constitutionality of an order is to follow due process, which means you then have to go to court to ask for clarity. See, when you're saying a user can abuse, and therefore I don't have to listen to a user who says that a rape video is on your platform, so remove it. Same way, if you feel that a government order is violative, you also have to go to court. No, it's about due process, it's about rule of law. So this is the, sauce for the goose, sauce for the gander thing. It applies both ways. If you want your clarity, you have to follow it through due process. And if you don't, then you will be made liable. But what MeitY has said is that, not everybody wants to go file a civil or a criminal case for them to get this remedy, right? So they have said they will create alternative simple remedies, which will start and stop with a request for a takedown. Just like 69A allows for blocking, here you could just apply. There will be a mechanism which will review the content and ask for the takedown. And since it's a regulated mechanism, it will be permissible under law. And that would be a very, very welcome move, because genuinely, every user does not have the bandwidth or the money power or even the time to keep going to court to get an order for them to take down content. There has to be a slightly higher responsibility from social media platforms. And on this note, again, for every user, the clarification I want everyone to take note of is there is a complete misunderstanding of the Shreya single judgment. Because whenever somebody talks about the judgment, the standard line you will hear is social media does not have to take down content. But that's not what Shreya Singhal said. Shreya Singhal just said that if social media does not take down content also, they will still retain their protection under 79. That's all. That still doesn't mean social media should not act. They can act. You as a user still have the right to write to them. And if they believe that this doesn't work, they will take it down. On many, many occasions in my practice persona, I have sent takedown notices and it has been acted on. So don't lose heart on that. You can still give it a try.
So you mean there is a process which is already there. All that we need to do is to make sure that we follow that process to the extent that, so that we don't have to rush to the court every time that we need to do anything.
Yes, you can still try by sending a notice directly to social media. There are multiple ways of doing that. Some of the things that happened because of Prajwala was this amazing move, which is to have simpler reporting buttons, more straightforward reporting buttons, even on every platform. See, Prajwala was a process where through consensus, we moved ahead a lot. And we also did it because it was not sensationalized. It was just brass tacks, hard brass tacks, and you just get it done kind of process, So you can either write to the platform, you can use the report button. You can also file your criminal complaints online through cybercrime.gov.in. And if you're confused about what are your remedies, how do you approach them, how do you file your complaint, what are the documents you need to put together to help people on all these simple basic questions for which they can't keep running to engage a lawyer. This was the reason why I set up cybersaathi.org.
Lovely.
You will find all your answers there, in fact.
So viewers, remember, that was a very interesting aspect of it, but do visit cybersaathi.org. I think she's put in a lot of information out there. But before we wind up, we have been talking a lot on the personal part of it, the user Twitter platform, our interactions as citizens of India. But we also have the enterprise tech aspect to it, and I know that on various fora we have interacted, and with other people also in your interaction, you have spoken a lot about cybercrime, about cyber security in enterprises. Um, the feeling that Subbu and me, we have discussed these issues at length even on in earlier episodes. But we would love your thoughts on how companies are actually, looking at cybercrime and cyber security. Are they doing enough? Are they forthcoming? I know that there's a whole question about their brand reputation. There's a whole question about, not coming out in the open very easily because they feel that, okay, fine, it will have an impact on their business. But what's your sense on this?
See, there are two aspects to your question, and yes, it's a very, very important aspect. The first is uh, one, I personally feel that the time has now come for corporations to have people with cybersecurity or cyber law expertise on their boards, because they have, and every company needs it. Because everyone assumes that it's only a technology company which needs it and we don't need it. But every company which is dealing with sensitive data, sensitive personal information, or data which is proprietary, all of them need it. And invariably, when I'm talking about my practice in cyber laws, and it's predominantly corporate, every alternate case is about a data breach. And out of those every alternate cases, 90% of the cases are what we call the enemy at the water cooler, right? An inside job. So you can try your best to put in just, people think, okay, draft some 20 policies and make it as tight as possible, it's done. It is unworkable. And this is what happened when COVID happened, because you needed policies which were workable in today's technology enabled world, which makes you work 24/7. You've come back home, you get a call from your boss, and the boss says, oh, that particular document, you have it on your computer, can you just send it? Or I can't find it on the mail, can you just send it? All of us have done it as bosses or as employees, right? Whichever way. When you are being asked to work from home, and this was not a situation pre-COVID, only post-COVID, right? It was very much there pre-COVID also. And you have policies which talk about you will not take data home, you will not access your company data from your personal computers, etc., etc. But you expect your employees to work 24/7. Let me tell you the other dangerous side of it. We talked about how the insider may be the person violating, right? But in 90% of cases, again, on the flip side, there will be where an employee has quit and joined a competitor. Everything is fine for 2 years, but when the competitors are succeeding, suddenly things will be pulled out from their work time, saying you took this document home. The policy said you cannot move it out of a computer, company computer. Therefore, you violated the law, right? So you then have vindictive prosecutions. So you can't have both sides. You can't run a prison as a corporate entity, right? Or a corporate entity like a prison, more precisely. So you need a situation where you have a workplace which is conducive for harmonious working, which protects the rights of employees as well as the employers, both ways, right? And you also need processes which will ensure that entry and exit mechanisms are duly followed, without it becoming a paranoid state. On one hand, you will have 30 different kinds of policies, including about the handling of passwords, etc. And for 10 days after somebody leaves, the password will not be changed.
Subbu is smiling out there because he wears two hats. One is, of course, as a veteran tech journalist, but more importantly, he's also an employee. And he knows that, okay, we segregate our content here. So tomorrow, like say, if I leave or somebody else, I'll be accused. So Subbu, I need your thoughts on this.
And one final thought on this. So one aspect is, yes, companies need to take this very seriously. But there is another aspect which they all ignore, which is the compulsory reporting mechanism. So India has a compulsory reporting regime, which is mostly followed in its breach. Again, out of fear, because there is no trust in the system. You're reporting to a government entity. It's a governance mechanism, but they don't understand it as such. And again, people question, but why should I report it? What are they going to do with my data? So does a government have to justify why they need your data for you to share it with them, when there is a law which says otherwise you are liable for 2 years imprisonment, or that you can be, you know? So ultimately there is, but again, in this kind of instances also, since governments now have to learn to work in tandem with corporates, we have to outgrow our license Raj mentality. We are all from the generation which has traversed both sides of this divide, right? So we have to get out of that mentality, and we have to assume, and I say this even to lawyers, I've seen my seniors do this. I myself probably did it in my early days. I don't know. You have to do all this to the client, right? And if the client asks why, because I said so kind of attitude, it will not cut ties any longer. Today, even a client wants to know, why are you asking me to do all this? And you have to patiently explain if you really want the action points to be effectively carried out. Similarly, it also will actually help government for better governance and for better compliance if they explain why they need it, but more importantly, what are the measures they are putting in place to protect this data that is being shared, so that a company's value is not adversely affected because of a leak from their side, right? So both sides, there is a lot of distrust, there is a lot of skepticism in government systems and the systemic processes, and therefore, consequent to distrust, either people don't report, people don't comply, all kinds of things happen. Or, as you have seen, Subbu, people think they can insist on what they want, and too bad for you if the law says otherwise, right? So
Exactly.
today we have to know how to use existing systems effectively. Only if we use existing systems, if new laws come in also, we can use it better. If existing systems we don't know how to use, how does it help us if 20 more laws come? So if you had a Nirbhaya case and then you had changes, 2013 amendments to criminal law, and women are still not safe, merely spouting words about women's safety doesn't help anybody. Show it
That is
in action.
that is
So be
exactly
it
why I was saying this.
technology, be it privacy, be it new laws, be it applying old laws. All I am looking for, and my top wish list always was and remains, effective enforcement. And
So
until such time, let's hope for responsible technology.
So your quick thoughts as an employer this time?
No, see, every employer, well, most of the employers believe that it can't happen to me. First, we believe that it happens to others. We are safe, we have put in everything, so it doesn't happen to me. Point number one. Point number two, the minute something happens, okay, we don't look at our systems, we don't look at our processes, we start looking at who has done it. Okay, that's the second problem. Third problem, even if we do come to know who has done it, do we then follow the process that is set out? And do we go the whole hog? For example, if there's a data theft, do we first report it to the police station? Do we file an FIR? No, we don't. We believe, let's not do this. Let's not complicate the matter. So that's the word we use. Let's not complicate the issue. No, you're not complicating the issue. You're supposed to solve the problem. And I completely agree with Nappinai. See, there is a huge amount of mistrust between the people on one side and the establishment on the other. It is very easy for us to sit here and say it is all the establishment's fault. It is not, right? A lot of responsibility, a lot of ownership has to be taken by us, which at least as employers, look, the reason why I'm saying employers or individuals, employers have more resources, individuals don't. So employers therefore have a higher responsibility to follow process. And as long as we don't do that, I remember this uh, many years ago, there was a Raymond's ad that came once, you know, which said very simply, how do you expect your child to follow your advice and ignore your example?
That's a good one.
You know, so as long as we don't do it ourselves, how do we expect anybody else to do it? Like, like Nipana was saying, yeah, we can go on saying women's empowerment, algorithms, new law, IT Act, data privacy, all that will come to a naught unless and until we as corporate citizens decide to follow the rules that are laid out for us and stop trusting to some extent. Let the other guys betray the trust first. Why do we assume that he's going to betray the trust? That's the whole problem.
A more human approach. That's what you advocate.
I have
And
a
I
very
think
simple formula for corporates, okay? Because you're right, 90% to 95% of cases I handle, they don't want to file complaints. They don't want to go to court.
Yeah.
So the formula is 4 Ps, right? Prevent, protect, preserve, prosecute. And it is sequential. So you have to first take your steps for preventing and protecting against data breaches, violations, cybersecurity incidents, everything, right? The preserve aspect is actually, I like to use a P there also, therefore I'm using that, but it actually comes in multiple usage, So the first part is, of course, if a violation has happened, and you will see whether the violation is with respect to an individual, it is a corporate or a nation state, the requirement is actually the same, which is resilience or a quick bounce back. The individual wants a quick takedown, protect the content from leaking further. Same with an economic offense, where they want to ensure that their proprietary data has not been compromised further. That it has been compromised, they already know, but they have to block it at the earliest possible instance. And again, for a nation state, they have to, one, protect and also bounce back, come back into action at the earliest possible time. So this is where a process driven mechanism works, to ensure that there is a stepwise thing you can follow. And as you rightly said, what is there on paper may be very different from what happens practically. So that presence of mind becomes more an individual aspect rather than process driven. What we really have to move forward is to ensure that it becomes process driven. And the next aspect of preserve is know how to retain your electronic evidence, the trail, because it always gets messed up and then the last part gets messed up. You can decide whether you want to prosecute or not later also. Resilience and bounce back is the more immediate requirement. But whilst doing that, ensure that you preserve so that you also preserve your right to prosecute later. And finally, on the prosecute part, especially for individuals, I always tell them, please prosecute, because then you will protect yourself against further harm and you will also protect others falling victim.
Others, exactly.
This for economic offenses, I tell corporates, please prosecute. Because as you pointed out, Subbu, early in the discussion, you said that you need to set a precedent, so that the precedent will act as a deterrent. And that is important for corporates to show that they treat their policies very seriously. So if that message doesn't go out, then you are likely to, you're otherwise going to have a paranoid situation where everybody is supposed to be scared, but nobody will comply. Sure. You're better off saying, I know now that I cannot take data. I know now to understand that what work I'm doing belongs to the company, so I should not take it away when I'm leaving the company. And that if I do it, I may be prosecuted, right? So with that knowledge comes a much higher level of deterrence than all the policies you put in place. So therefore, economy should prosecute. When it comes to nation states, it's a disaster because we still haven't even put in place effective mechanisms for that. So we will reserve that for another day. But remember the 4 Ps, even though you may come to the last later, prepare yourself for the rest. That way you will actually save a lot more money than what you would by going low in terms of the prevention and protection aspect and then spending so much on prosecution and not really getting much.
So friends, we would have loved this discussion to continue, and I know basically there's no end to this topic. I hope you all have benefited from this, from the insights that Nappinai has shared with us. I think the take homes are very clear that ignorantia juris non excusat, kind of ignorance of law is no excuse.
Absolutely.
So you need to brush up your knowledge of law. Remember that while we can always sit across the negotiating table to discuss, but there's a time to understand the difference when you want to sit at the negotiating table and when you need to prosecute, so that you can set up a precedent. But yes, I think it's very, very clear that we need to be aware of what's happening in this country. Technology and law are going hand in hand. It's a very, very important topic for all of us and quite an eye opener. So, Nappinai, thank you very much for your insights. Thank you for being on this show. And viewers, if you like the insights, please subscribe to this channel and look forward to having you all back again next week on the Weekly High with LSD show. Thank you.
Thank you so much.
Thank you, Nappinai. Thank you. Bye-bye.